So we're very, very excited about having James Westbury. He does a great job of speaking and has quite a bit of experience managing and handling high-speed pursuit claims. So I will let him start. So without further ado, here's James Westbury.
Thanks, Dan. Appreciate the invitation to come in today and speak to your attendees about high-speed pursuits and how the law enforcement agencies can decrease the risk of high-speed pursuits and hopefully minimize liability. I've been handling these kind of cases now for 18 years. I have been doing government defense work for 18 years, and I've handled several pursuit cases. Also handled a lot of cases brought under Section 1983 for false arrest and cases that allege excessive force. And I've also worked for the Georgia Municipal Association for many years as coverage counsel. So I've kind of been looking over other claims that other lawyers have handled, and I've gained a lot of experience in dealing with these. High-speed pursuits is one of those areas that I think jurisdictions can decrease their potential for injury and loss a lot by providing training and being proactive with their membership. What I'm going to do today is talk about federal law as it relates to high-speed pursuit, state law, defenses that can be asserted, and then go over some best practices and hopefully engage with some of your attendees in some questions. We'll first talk about federal law. The big federal case that deals with, going down to the next slide. There you go. The big federal case, first let's talk about the potential plaintiffs who you can have in a pursuit case. Of course, you've got the fleeing suspect, but you've also got the passenger and most importantly, the innocent bystanders. Now, in the eyes of the law, the passenger and the innocent bystanders are going to be looked at as the same, and the fleeing suspect is going to be looked at completely different. The seminal Supreme Court case on high-speed pursuit is Sacramento County versus Lewis. It's a 1998 decision of the U.S. Supreme Court. It involves a situation where a pair of teenagers were witnessed speeding by two deputies and fled when the deputies tried to pull them over. Ultimately, the boys crashed and the motorcycle tipped over, and Lewis was killed. The case went all the way to the U.S. Supreme Court, and there were a couple of holdings in the case that were very significant. First of all, we were talking about the passenger, not the fleeing suspect, and that's critical when you look at these cases. And the analogy would be if a police officer shoots at a suspect but hits a bystander nearby. If the officer hits the suspect, that is use of force through means intentionally applied, and it's looked at under the Fourth Amendment standard of objective reasonableness. If you hit somebody that happens to be standing nearby, that's an accidental injury, and that's gauged under the 14th Amendment. And the Supreme Court defined the standard in that type of case as conscience shocking. And what that means is an intent and purpose to cause harm unrelated to the legitimate object of arrest. So what that means in practical terms is it's a very high standard, and it's almost impossible to meet if an innocent bystander is injured in a high-speed pursuit. It's going to be very difficult to bring a federal claim. Next slide, please. The next case I'll talk about deals with the actual fleeing suspect, and the case is Scott versus Harris. And when we handle these cases over the years, there's an expert who comes up over and over again. His name is Jeffrey Alford. He's a PhD researcher in criminology at the University of South Carolina, and he's testified again and again that the use of the police car in a pursuit is the deadliest kind of force. And I've always kind of had this question in my mind, well, isn't the suspect also using deadly force when he runs from the police officer or the deputy, and if it's deadly force, can't that be met with deadly force? Well, that was exactly the situation that confronted the Supreme Court in Scott versus Harris. You had a man named Victor Harris who was clocked speeding, and when Deputy Scott tried to pull him over, he ran. What happened was there was a 9-minute pursuit of speeds of over 90 miles per hour over in Coweta County, Georgia, and Scott wanted to pit Harris, and the supervisor gave him the permission to take him out. And Scott determined that he was going too fast to safely pit him, so he rammed him directly. Harris ended up wrecking and breaking his neck and basically becoming a quadriplegic. So the case went up to the Supreme Court, went to the U.S. District Court in the Northern District of Georgia, up to the 11th Circuit. The 11th Circuit denied qualified immunity to the deputy, and the case goes all the way up to the U.S. Supreme Court. And the Supreme Court said several things. First, that the decision to ram was actually a seizure. It's a seizure that's gauged under the Fourth Amendment objective reasonableness standard. And it is the use of deadly force, so it has to be gauged under the Tennessee versus Garner decision, as you would always look at a deadly force claim. But the court concluded that there was no problem with the use of deadly force in this circumstance because it balanced the harm to Scott versus the harm to the public. And the court concluded that it had little difficulty concluding it was reasonable for Scott to take the action that it did. And what this means is that in almost any situation where a suspect flees, even for a minor traffic offense, from a federal standpoint, the use of force is not going to be unreasonable, even up to the point of killing or injuring the fleeing suspect. So we go back now to our potential plaintiffs, and we have a little bit more color to put on the standard that's going to be applied. First, the fleeing suspect under the Scott versus Harris decision, that's almost always going to be okay. Police officers attempt to terminate a high-speed car chase that threatens the lives of innocent bystanders does not violate the Fourth Amendment, even if it places the fleeing suspect at risk of serious injury or death. Now, on the other side of the scale, we have the passenger and innocent bystanders, and our standard from Sacramento County versus Lewis is that it has to be conscience shocking, which means an intent to cause harm unrelated to the legitimate object of arrest. Finally, we have a third case out of the U.S. Supreme Court. It's called Plumhoff versus Rickard. It's a 2014 case, and there the plaintiff was actually the plaintiff was the fleeing suspect, and he had a passenger in the car, and the police shot at the vehicle 15 times. Ultimately, it wrecks, and the two people in the car die. The fleeing suspect actually made the argument in the Supreme Court that the amount of force was unreasonable because there was somebody else in the car. So he was basically saying, you can't shoot at me because I've got somebody else nearby. And the Supreme Court rejected that argument, relying on Scott versus Harris, and said that the force was still reasonable, and most importantly, determined that the issues related to the passenger couldn't be vicariously asserted through the driver of the car. So the takeaway from these three decisions is that it is almost impossible to have a plaintiff successfully bring a pursuit case under federal law. And for that reason, most of our pursuit cases are brought in state court. The next slide, please. The state statute that governs high-speed pursuits is OCGA section 40-6-6. This statute is the focal point of all of our litigation in state court under dealing with high-speed pursuits. We talk about this statute when we're raising defenses, when we're filing motions for summary judgment, when we're drafting jury instructions, when we're arguing to the jury. And the issue under the statute is whether the officer's decision to initiate or continue the pursuit was a reckless disregard of proper law enforcement procedures. And in order for the decision to initiate or continue a pursuit to be a proximate cause of an injury or death from a tort law standpoint, the plaintiff has to prove reckless disregard. That is set out in subsection D2 of the statute. In subsection D3, it makes clear that the existence or absence of immunity still exists even if a plaintiff can make out a case under the reckless disregard standard. Next. In subsection D4 of the statute, it's made clear that claims, and this is the latest iteration of the statute. This was not a statute that was in existence in its current form. When I tried my biggest case in the pursuit arena back in 2005, since that time, the state has adopted a statutory waiver of sovereign immunity involving motor vehicles. And the statute makes clear that if it's a pursuit case, the case can be brought under that statute. Why that is important is if you look at that second bullet point here, it says that claims must be brought under section 3692-1, which waives sovereign immunity. And then the next bullet point, a person bringing an action against a local government entity shall not name the local government officer or employee individually. That is very significant for all the people attending this webinar today, because what it tells us is that even though your jurisdiction might get sued, if you engage in a pursuit, you're still entitled to your immunity. And if the plaintiff's lawyer decides to sue the jurisdiction, they cannot name the individual personally. This is the case in any incident involving a motor vehicle. They're not supposed to name the officer individually. It still happens. Plaintiff's lawyers don't even know that this is out there. I've got a plain vanilla automobile accident case I'm defending right now for a city where an officer was named, and I filed a motion to dismiss the officer, and the plaintiff voluntarily, dismissed that. Adding the officer to the case really doesn't add anything, because there's a waiver of the city or county's immunity for the use of the automobile, and both cities and counties waive immunity up to the amount of the insurance they have anyway. So having the individual officer, and they're barring the exceptional, peace officer who's got millions of dollars in personal assets, it really doesn't add anything.
Well, don't you know, most of the law enforcement at least make $1 million a year.
Absolutely.
So there, regards to consequences, if an attorney does place name one of the officers involved in this, the defense counsel more than likely will just say, hey, you can't do that, and they'll remove it.
Absolutely.
Okay.
Absolutely. It's if anybody works as a certified peace officer for any length of time these days, there's a good chance you're going to get named in a lawsuit. And typically what's going to happen is the carrier or the jurisdiction is going to get a defense lawyer that's going to represent both the individual and the entity or the agency, and it's not something to get worked up about. That's very, very standard these days. All right, so now we've got the statutory framework. The statutory framework, and I want to talk about a few cases that give us a little bit more color on what the landscape looks like in these types of cases. Cameron versus Lane was a big case that went to the Supreme Court of Georgia in 2001, and this is before the statute I just read that said you automatically get to come out of the case. In that case, an officer was sued individually for engaging in a high-speed pursuit, and the trial court refused to dismiss the individual under their official immunity. And just as a refresher, official immunity is the immunity that any police officer enjoys under state law if a claim is brought for something they engaged in a discretionary capacity. Now, a lot of times plaintiffs' lawyers will try to come in here and they'll say, well, you violated your policy, so that's violation of a ministerial duty. The ministerial duty is sort of the Loch Ness monster of Georgia law, because we know what it is, we've talked about it, but nobody's ever seen one. That would be, a very specific, discrete action that you have to take under defined circumstances. And any kind of emergency driving, whether it's driving an ambulance or engaging in a high-speed pursuit, is going to always be considered a discretionary act. And under prior case law, the officer always gets to come out of the case individually under the Cameron versus Lang decision. The earlier iteration of this case was the Court of Appeals decision, and in that case, the decision was actually known as Lang versus Beecham. And that decision relates more to whether the case can proceed against the entity. And in the Lang versus Beecham case, the court said as long as there is evidence of reckless disregard of proper law enforcement procedures, that is sufficient to overcome summary judgment. And that evidence is presented in the form of expert testimony from a police procedures expert, such as Dr. Alpert, who I mentioned a few moments ago. The takeaway from that is, if an action is filed in state court and a plaintiff can come up with a police procedures expert, it's almost always going to be impossible for the jurisdiction to get summary judgment, and there will be a trial. And let me explain what this means. If you engage in a pursuit, you're on the clock, you're acting on behalf of your jurisdiction. Your jurisdiction is going to be vicariously liable for any tort. And this is the same if you're working for, a police department or a sheriff's department, or if you work for Walmart as a driver. If you're engaging in any kind of actions and you commit a negligent act or omission on behalf of your employer is going to have imputed liability. So what happens in a pursuit case is the employer might stay in the case because there's a police procedures expert, but because you still retain your immunity, the officer is always going to come out of the case on a motion to dismiss. There's a myth out in law enforcement that if I think a guy is driving drunk and I don't pull him over, or if he runs from me, I'm going to get sued whether I chase him or if I don't chase him, because if he goes and hits somebody else, and that person or their family is going to sue me. Well, that's totally incorrect. There's a case called Landis versus Rockdale County that presented that exact same scenario, where a sheriff's deputy didn't pull somebody over who he thought was intoxicated. Somebody got hurt, and the court came back and said that police officers do not owe a duty to the general public, and this falls under the broader public duty doctrine, which is basically a duty to all is a duty to none. You've got to have a specific, special relationship with a person in order for police to have a general duty to protect. That would be, the classic example would be, if your house is being broken into or it's on fire, and you call and, they say, well, we're on the way, don't do anything. And then if they don't show up, that call has established a special relationship with a definable plaintiff. But there's no general duty that applies to the general public. So the takeaway from that is, if you ever make the decision to not engage in a pursuit, you're not going to be sued for that. So that there's a myth out there, but I want all your listeners to understand that you're not going to be liable for a decision not to pursue. Next is a case called City of Winder versus McDougal. This is a case where a 14-year-old took her father's car without permission and engaged in a pursuit and was killed. And the court held that the reckless disregard standard does not apply to the fleeing suspect, and the case can only proceed if there was actual malice or actual intent to cause harm. And the import of that is the fleeing suspect never has a case under state law. And when this case came down, I was actually handling a case involving the city of Greenville where a suspect had fled from a traffic stop, and the officer broke off the chase, and the person went like 6 miles down the road and went around a sharp curve and hit a pine tree. And I vividly remember, coming to the point where he went off the road, and you could see the curve and the pine tree beyond it, and you could see exactly how that happened. But this case came down, and the plaintiff had to dismiss the action because it was not maintainable.
So again, based on this, you would say in this circumstance, the 14-year-old girl took the car, they city of Winder did a pursuit, and the court said, and the girl died, and the court said any pursuit that the person fleeing, the fleeing suspect can never get damages. Is that
right? They're basically not owed they're not owed a duty, not under the reckless disregard standard. The only thing you can't do is, as a matter of state law, is intentionally harm them.
Yeah.
And it basically makes all these cases impossible to bring. I'll tell you how they typically come up, and this has changed a little bit with tort reform. The way traditional joint and several liability works is if you have an indivisible harm that has more than one cause, such as a fleeing suspect and an officer, if their combined negligence hurts or kills somebody, traditional tort law would call that a joint tortfeasor tort, which means the joint and several liability. And in that circumstance, each of the parties is jointly and severally liable. That means you can sue any of them or all of them or sue them separately. So in these pursuit cases, what would happen was you would have the plaintiff's lawyer come in here, and you've got the biggest, dirtbag, what you've ever heard of, who ran from the police, has no money. And they sue that person, and they sue the cop, and they sue the agency. And the plaintiff's lawyer would stand up in front of the jury and say, all we've got to do is prove that they were 1% at fault. Well, if you're 1% at fault and it's a $2 million verdict, you get to pay $2 million, and that's the way these cases were brought. And when I was trying the Banks case that I'll talk about later, tort reform was enacted that same week. And I remember when we were waiting for the jury to come back, the plaintiff's lawyer, a very good plaintiff's lawyer, and he said, this may be one of the last cases like this we see, because tort reform included apportionment of damages. And that it used to be the case that you had to have contributory negligence of a plaintiff before you could apportion fault among different defendants. But with the tort reform statute, the defendants can apportion damages in every case now. So what that means is if you have the situation where you have a fleeing suspect who runs and kills or hurts an innocent motorist, if I'm defending the case, I'm going to be arguing for most of the fault to be put on that person. So that's helpful, and I think that's part of the reason you don't see quite as many of these cases anymore. Okay, now we're getting down to the crux of what I want to talk to people about so they can understand the legal framework for these pursuit cases, and that is the actual decision making. Most of your agencies are going to have a discretionary policy, and the decision the officer has to make instantaneously and has to be able to document and explain is how he balanced the need to apprehend against the danger of the pursuit. The need to apprehend is the offense for which the stop is initially made. It's not the danger created by the suspect's flight. And your policy will define it this way. And I will, Dan's throwing up there some different factors to consider. On sort of the left-hand side of the scale, the offense, you're going to have, is it a traffic offense? Is it, some other misdemeanor? Is it a nonviolent felony? Or you move on up the ladder to a violent felony or even a violent felony in the officer's presence. So, you know, minor traffic offenses would be the least serious thing that you would be justifying the need to pursue with. And then on the right-hand side of the scale, we're going to look at the danger of the chase. The highest risk chase is going to be where, you know, you've got frequently intersecting streets, poor weather, blind curves, pedestrians, traffic congestion, speeds over 80 miles an hour, unmarked police vehicles, which should never be the lead vehicle, hazardous maneuvers, number of cars in pursuit, excited officer, or no supervisor. Moving on over to the moderate risk, you got unmarked vehicles, intersecting streets, lighter traffic, lower speeds, calm officer, hazardous but not extreme maneuvers, an effective supervisor, an authorized number of vehicles. And finally, you have the lowest risk chases, which involve, you know, straight roads, good services, clear lines of sight, no pedestrians, few intersections, good weather, and so on and so forth. And what your officer is going to be forced to do, you know, is justify, if there's an incident, the need to, whether there's an incident or not, you still have to justify the chase. So what I want to do is talk a little bit about best practices, and then I'm going to talk about some specific cases that I've had to articulate some of these. First of all, pursuit is a high-risk task for which the department must have a policy. You've got basically three general types of policies. You've got a restrictive policy, which is basically violent felonies, a discretionary policy, which works just like what I just articulated, where you've got to balance the need for the chase versus the danger of the chase, and finally a no chase policy, which very few jurisdictions, especially in a state like Georgia, would have. Training must be provided under the policy, and there's sometimes a misconception. I don't know if this is much true today, but it used to be true among the police executives that this meant training on the EVOC policy. EVOC is just driving the car. It's not the decision making, but you need to train your officers on your policy, and you need to give specific examples and walk them through, you know, how decisions have to be made. You have to have planned training, and there ought to be refresher training, because the skills are perishable, and you need to document that training. When a chase happens, the officer should always be in communication with a dispatcher, and there needs to be a neutral and detached supervisor who's involved, who can call off the chase. This is important because when the officer's in the heat of the moment, the natural instinct is going to be to continue the chase, and the officer's going to have a lot of adrenaline. But if you've got a supervisor who can listen to what's going on, that person provides a means to regulate the chase and call it off if necessary. Once the chase is completed, the officer needs to be able to articulate and document the decision, and videotape is critical. In the Scott versus Harris decision, the Supreme Court actually undertook a fact-finding exercise of its own, which is highly atypical, but they did that based on the videotape from the police cruiser that was involved. I'm going to talk about some specific cases to kind of give you a flavor for what this looks like in real life. The biggest case I had in this area was called Banks versus City of Hampton, and I think Dan's putting a diagram up on the screen. This is a diagram we used at trial. Basically, these are parallel images of the same roadway. There's the phase one is the pre-pursuit phase, and phase two is the phase which is when the pursuit happened. Over near where that 55-mile-an-hour sign is basically the Atlanta Motor Speedway. And around midnight on a July night back in 2000, Officer Jeremy Pirtle was out on routine patrol across from the racetrack, and he saw a car come past. and he could tell the car was speeding. So he pulls out across the lanes of traffic and gets behind the car and clocks it going around 80 miles or a little better, and initiates a traffic stop once he has paced him long enough to make the stop. And sort of a low speed, not even a chase goes on, where the driver kind of gradually decreases speed, and it's really giving the officer all of the indications of a drunk driver. When he finally does, 2 miles down the road, come to the place where he's going to stop, he's in the left-hand turn lane, and he's really acting drunk. The officer takes off his seatbelt, and as soon as he does that, the guy does a U-turn through the red light, and you can see it on the video where the officer comes around behind him, and then he does the most dangerous thing possible. The suspect jumps across the median into the lanes of oncoming traffic and takes off. The officer gives chase, and within a few hundred yards, he ends up getting bogged down in traffic, and the police cruiser was not a police model Crown Vic. It was not fast enough to keep up with this little Dodge Neon, and you can see the fleeing suspect just leave the officer behind. And we find out after the fact that one of the reasons the lights disappear is that the suspect actually turned his lights off. So the chase takes place in less than 90 seconds, and when the officer finally breaks free over here in phase 2, and he comes around the corner, he comes up and there's dust everywhere, and the fleeing suspect has hit this 22-year-old girl who was headed back home after a night out with friends, and 22-year-old Rashonda Banks, she was about to graduate from Georgia State and get moved back to Barnesville to be a kindergarten teacher. So you've got a very, very sympathetic situation here with a horrific injury, and as the officer suspected, the fleeing suspect was 0.28 on his blood test. So the plaintiff's lawyer filed suit on behalf of Miss Banks' mother under the Georgia wrongful death statute, and we end up getting the officer out of the case based on official immunity. And the case went to trial, and basically we had a battle of the experts. We had a very good expert named Patrick Gallagher, who has done a lot of work in the police area over the years. And the plaintiffs used Dr. Jeffrey Alpert and a guy named Michael Cosgrove, who retired from the Miami-Dade Police Department. And the jury hung 10-2 in our favor. And basically, Officer Pirtle articulated the need to apprehend the fleeing suspect as the need to get him off the roadway. He wasn't really trying to apprehend him, because once he came into the lanes of oncoming traffic, he was a terrible danger to the oncoming motorist. And Pirtle was basically trying to either knock him off the road or warn the oncoming motorist. And they had a police expert who testified that this was not proper law enforcement procedure, because you couldn't take into account the chase in weighing out the need to chase. And we had an expert who testified that it was, in fact, proper law enforcement procedure. The case went to trial in Henry County, which is a very conservative jurisdiction, and the jury hung 10-2 in our favor. The case went up to the Court of Appeals on a venue issue, and we ended up having to come back to a much less favorable jurisdiction and settle the case before it was tried the second time. That's a case where it's a much harder judgment call to decide whether to engage in the chase or not. Another case that I handled that's kind of on the opposite end of the spectrum was a case involving the city of Luthersville that got a lot of publicity about 15 years ago. In that case, a Luthersville officer was outside his jurisdiction and saw a lady with children in the car. I believe it was running a stop sign, and he tried to pull her over, and she ran, and a chase went on for about 20 miles over several cities, at least 2 counties, went through Peachtree City, through a shopping mall parking lot on a Saturday night, and the guy got back on Highway 54 and T-boned an innocent motorist in a minivan and killed him. And we were called into that case early on to help investigate and make a recommendation as far as settlement, and it was absolutely indefensible. The city had $600,000 in liability limits, so we were forced to immediately settle the case and get the city and the officer out of it. What was somewhat alarming is that when we looked at the officer's pre-employment background at other police departments, he engaged in similar activity where he had a lot of high-speed pursuits. And something that I would recommend to people who make decisions to hire officers is always look at the personnel file at all the prior departments. And typically the officers who get in trouble, it's not isolated. If you look at an officer's jacket at his prior cities or counties, if he's got an excessive number of complaints of excessive force, false arrest, or police pursuits, that's probably somebody that you need to really think carefully about whether you need to hire them or not. That case was concerning too, because despite how high the bar is for a federal case, I felt like had the case not been settled, it was so egregious that they may have met that shock to the conscience standard. A couple other cases I'll talk about deal with injuries to the fleeing suspect. And the most common injury to the fleeing suspect has nothing to do with a car crash. It has to do with the use of force by the officers who finally catch the person. I had a case for another city a few years back where there was an intoxicated suspect. He engaged in a chase and wrecked his car, and the officer was really hyped up and just on video just beat the living tar out of the guy. And we had to deal with a Fourth Amendment excessive force claim that we ultimately settled. There was another case where it was pretty recently, and it was on TV, where a city and county officers chased a guy on I-20 who they thought had committed a violent felony, and ultimately they were able to catch him when he wrecked his vehicle, but they engaged in a much more restrained approach with the use of force. Because once you catch this guy, as your attendees are going to know, this person's unpredictable. They run from the police, and you don't know what they're going to do, so you're not really going to give them the benefit of the doubt. But there were about 5 officers on the scene within a couple of minutes, and they subdued the guy. He had very minimal injuries, and that's the kind of professional, approach that you hope your officers will take. With that, I'll take some questions from your listeners.
Again, if you'd like, you can type a question in. I'm going to kind of go through the board and see if anybody has any questions. Brent, are you out there?
Yes, sir. I'm still here.
Any questions based on the presentation?
No, I know that we've reworked our pursuit policy here recently and everything like that. So once we turn this over to internal affairs and with our police chief and everything, I'm sure they'll have some for you to follow up with, but none at this time. Thank you.
Thank you. David Gibson, are you out there? Holly Stevenson, are you out there?
Hey, Dan, I'm here.
Got any questions based on the webinar?
I don't think so. Very interesting information, though.
Very good, very good. Well, thank you very much. Keith, are you out there? Roscoe, are you out there?
Yes, we're none from us, thank you.
No questions? Okay, thank you so much for participating. Well, with that being said, I'm going to say thank you so much to Mr. Westbury for gracing us. I'm sure that if you have any questions in the future, you could shoot those to me. I will, again, if you're registered to the class, I will give you his contact information, and I'm sure he wouldn't have an issue with sending him questions. If not, you can direct those to me. Again, I'm going to be sending a recorded version of this out to everybody, along with the PowerPoint presentation, along with our model pursuit policy. So please don't hesitate to give us a call if you have any questions, and have a safe rest of the week and summer. We'll talk to you later.